2, you're on.
We're back. This is the Joint Information Technology Oversight Committee, and we are back from our morning break. And we have with us next from Legislative Counsel, Maria Royal, who has been the attorney supporting this activity for quite some time. So Maria, the floor is yours.
Great. Thank you very much, Senator Broad, committee members. I am actually going to pull up momentarily a presentation that I did last session that overviews kind of the regulatory landscape that applies to broadband. Mostly that looks at the Communications Act, which is the federal law, 1934 law that regulates telecommunications, including eventually including broadband. But it also, the presentation will talk about some other legal authorities that the state has, as well as the federal government. So there's a lot of information, and it is pretty complicated, technical, dynamic industry. But my understanding is this will be familiar to many of you, but it will also help to kind of level set. And then if there are particular areas of focus that you would like me to look into further and come back at a subsequent meeting with more detailed information, then I'm happy to do that as well. So with that introduction, looks like
You're good.
Yep.
the document is up and it is posted. Thank you, Mike. So I think I gave enough of an introduction to get things started, if that makes sense to you. And there's a lot more in here than I'm going to go over today. This is, I think, by the chair's instruction, kind of keep it high level for purposes of today's discussion. So, I'm going to go through, I'll talk about each slide in the presentation, but really it may be a resource for you to kind of go back and look at more thoroughly. So not a lot of detail at this point in time, particulars of each slide. But again, people talk about the Communications Act, 1934. This was the federal legislation that established the FCC. The Federal Communications Commission, which regulates, as I said, telecommunication services. And you will hear a distinction a little further on between definitions and classifications. What is a telecommunication service versus what is an information service? Because there are significant regulatory ramifications for how a service is defined. But at least in 1934, we're talking about, to a large extent, telephone companies that operated intrastate, that is within the boundaries of the state. That was the environment at that time. But in terms of the mission, something to kind of keep in mind of what the FCC's goal is as it's regulating or not regulating, choosing not to regulate technologies such as broadband. Its mission is to make available, so far as possible, to all the people of the United States, a rapid, efficient, nationwide and worldwide wire and radio communication service with adequate facilities at reasonable charges. So, just about the current composition of the FCC, there are 5 commissioners. They're all appointed by the president and confirmed by the Senate. The president selects the chair, and only 3 commissioners can be of the same political party at any given time. This is in part why there's been such a kind of regulatory ping pong, because different administrations have different policies, different goals, just different ideas about how the internet should or should not be regulated. So when there's a new president, there's a new administration, there's generally a shift in policy, and that just creates a lot of uncertainty in general. So just keep that in mind. So I believe right now there are 4 members on the commission. President Biden has not yet appointed a chair. Jessica Rosenworcel is serving as the acting chair at this point. So there's a 2-2 kind of tie. So one would expect that when there is a chair appointed, there may be some increased action and potentially changes in policy that are currently on the books. So that's just to kind of give you.
Is the vacancy a Democrat or Republican vacancy? Do you know?
I believe right now it's a 2-2 Republican Democrat, so that
Okay.
the chair will most likely.
Most likely.
be Democrat.
Okay.
Is the vacant position specifically the chair, or would one of the existing members be promoted to
One of the
chair?
existing members could be promoted. So right now,
And that
Commissioner
wouldn't,
Rose Horsel is the acting chair. She could be promoted as a chair and then fill her position, her current number. You know,
correct, and that wouldn't reset the 5-year clock, right?
that would, for her term,
Correct.
maybe not, although I think her term is almost expired. She might be in a little window where it's officially after her term. I'd have to check on that, but
Okay.
yeah, they would fill whatever remainders left on her term and then have a 5-year term most likely extended. So I'd have to look at that, you know, but I think I did just read that she's coming to the end of her 5-year term. So there's definitely some pressure to, in addition to whatever policy objectives they had to take some steps in that regard.
Thank you.
So one of the kind of, again, broadly speaking, in terms of federal state jurisdiction, something to keep in mind is this notion that's embedded in the Communications Act of federalism. That meaning that at the federal level, through the FCC, that entity has jurisdiction predominantly over interstate communication, so between among states. Whereas the states have jurisdiction over intrastate communications within their boundaries. Obviously, and spoiler alert, I'm sure you're all aware, when you start talking about services that are mixed, both intrastate and interstate, where do you draw the jurisdictional lines? That happened in the telephone industry as well, at a slower pace, because the development of that industry was much slower than broadband, but trying to play catch up. And that's, I think, in part why there's so much litigation, because there's been so many changes in the technology and the FCC has not quite been able to keep up with where those jurisdictional limits are. So then,
Senator Pearson.
Just on this point, it's almost an obsolete distinction, right? I mean, there is, I'm trying to think of anything we would with a straight face define as intrastate at this point, given that, I mean, I could use my cell phone in Highgate and hit a tower in Canada or New York just as likely. So is that reflected in a changing landscape, or are we just sort of, you know, does the country and the rest of the states cling to this older definition while we still can? I mean, I'm just curious
I think
if you have
is
thoughts.
reflected. You know, I think that this mixed use notion is something that's not unfamiliar to the courts and the FCC. Just in long distance and interstate toll, you know, interstate calling, you know, things, hardware that can provide telephone service. It's long, you know, so they've looked at it in an older context. It's reflected, I think there is an understanding of, you know, the interstate nature of broadband. And then what they've been trying to kind of delineate is what falls within the traditional state's jurisdiction. You know, how can you regulate and protect the public or for the public welfare? Each state will have its own needs, you know, over a service that, yes, it's interstate, but if the primary objective is to protect the public welfare within a state, you know, as long as you're not impeding the federal objectives or in some way regulating beyond the state's borders, you know, and that gets into more like a Commerce Clause analysis, right? So the state, Vermont, all states regulate to some degree interstate commerce. And unless the federal government has specifically preempted that, states can do that, you know, but it really depends on the extent, if the impact on interstate commerce is great, that it's interfering with federal policies or right? So I know I'm not really answering your question because it's something that everyone understands, but exactly how, what states can do is not that clear and will likely be at some point subject to litigation. And ultimately the courts will have to decide. So I'm sorry not to be
No, that's
more specific than that. but it's-
confusing. Thank you. But
It
that,
is.
you're helping me.
Has there been any recent litigation? Or is there a string of cases that are helping to better define where those boundaries are? Or is it still just entirely uncertain and physical?
Gosh, there's so much case law, and so just what comes to mind more recently is the Mozilla case, which had to do with net neutrality. So under the Trump administration, under Chairman Pai, when broadband was reclassified as an information service, that was, long story short, that was challenged in the court system. And basically the courts upheld the definition, the classification as an information service. But what the FCC under Pai's leadership had done also was attempted to preempt all state regulations of the internet. This was called the preemption directive, incredibly broad. You cannot do anything to regulate broadband, anything that might interfere with what we're doing, or just, we want an absolute policy of non-regulation, right? Significantly in the Mozilla case, that directive was vacated. And what the court said, this was the DC Court of Appeals, basically was, no, that's too broad. The states have authority to regulate, and they said intrastate broadband, and going forward, it's going to be a very fact-specific inquiry. What does the state want to do? Why does it want to do it? What is the burden on, what's happening, outside of the state's jurisdiction? So it set the standard and opened the door. That this, what we had been operating under the preemption directive, which don't do anything, that's now been vacated. Then the question becomes, okay, now what can we do? And so more recently than that, I don't know that there's been anything, well, I'm sure there, anything that really kind of dispositively looks at the issue and draws some lines. There, as you can imagine, cases come up all the time, whether it has to do with siting, small cell siting, or fees, or, so depending on the area. And that actually is a question. I know you want to kind of keep this high level, kind of level set, but there may be areas of particular interest to the committee that you'd like me to focus on and say, well, okay, in this area, what have the courts decided, and where do we have room potentially, and flesh that out a little bit more. So
Fine, this is for now, this is fine.
Okay.
This level is fine for now.
okay, great. So I'm not going to go over kind of the historical developments. I'm not sure that that's helpful right now, although, just as a reminder to most of you, you often hear about the Telecommunications Act of 1996. This was basically an overhaul amendment of the Communications Act. So it's always still the Communications Act, but it was the Telecom Act that significantly changed that federal law and what some of the requirements are. And that was when there was a real shift towards and push for deregulation and competition, and certainly in the telephone industry, with new providers coming in, and the states were basically told to don't have barriers to entry, let new companies come into your state and compete on a competitively neutral basis. And the more competition, the better for the general public. So this is kind of the framework that we're under right now, except that broadband is changing. We were talking 1996, and this overhaul was really had to do with the telephone industry, although there was broadband, there was internet and advanced communication services. But how that technology has evolved and how it's used obviously is changing, which is impacting kind of where things are currently. So I've listed here, along those lines, I'm not going to go through all of these, but, some of the more significant provisions of that 1996 Act, regulatory forbearance. This is the notion where the FCC can forbear from applying requirements to telephone companies. And if the FCC does that, then the states also are preempted from applying those standards. Their interconnection requirements, again, promoting different providers to interconnect their networks with one another. Their network elements to kind of open up and promote competition and new companies, removing barriers to entry. There is also, kind of predates this, but a more expanded notion of universal service. That, the carriers of last resort in particular have to provide service to their consumers. And then there are also additional programs. The Lifeline program you're familiar with, which is a subsidy for low-income folks. Great program, which helps to bring broadband to schools and libraries and rural health initiatives. So, as well as promoting competition, there are specific programs, universal service programs, that do seek to kind of make sure that everybody can benefit from the new technologies and services. And that whole subject of universal service and universal service fund, both at the federal and the state levels, a whole area which we can certainly talk about more. If that's something that
As you talk about things like carrier of last resort, it's solely related to telephone. It has not been extended, and that concept, has anyone attempted to say that it should be expanded to broadband as well? Or that would be, I would assume, a legislative fix as opposed to the notion that, well, telecommunications, the whole definition has changed over time.
Right. Well, there definitely have been those who have pushed for that kind of a responsibility, that carrier of last resort responsibility and people have different ideas about how to do that, but within, the internet realm. And that's kind of the conversation that you hear people describe. Well, broadband is an essential service and it should be regulated like a traditional utility, not so much like the phone company right now, because that's so deregulated, although there are carrier of last resort responsibilities. But, on a more extreme, some people might say it should be regulated like in our state as like an electric company, where they have service territories, or there is at least some carrier that has a territory that they are responsible for ensuring. And that's a hotly debated subject about whether that's necessary. And those are just some models I'm throwing out, whether they would work in broadband with all of the different providers right now. I mean, obviously there are wireless providers that can go to the remote areas, and then there are wired services, whether it's fiber or cable, capable of being built out, but you already have an overlap. And what's acceptable and what, that is definitely something that people are discussing.
Are you aware of any cases that are going to the courts right now that touch on this area that may be going to the appellate level?
On whether, for example, it's like a utility. I'm not aware of anything right now that states have done where they've tried. I think we're in a little bit of a wait and see because of the new administration, because the FCC may take action that, treats broadband more like, if not a utility, but, gives expanded authority for both itself and for the states, right? So they may reclassify broadband. Worst mask I've ever had. I guess I never really talked to people when I'm wearing it, so sorry about that. They may reclassify broadband once again as a telecommunication service and then decide, within that regulatory authority, what makes sense for this service. So I think a lot of people expect that may happen, but I don't think that's a done deal. I think because, they're always looking at the level of competition and what are the new technologies, who's entering the market. So I think it's pretty fluid and dynamic in terms of what's the best solution, as you can imagine. Not really going to talk too much about the history. I sometimes like to just, remind everybody, the types of broadband technology. When we talk about wired, you're not talking about just fiber or coaxial cable. You're also talking about the legacy DSL to copper lines, because that's obviously a big issue in Vermont. There's still So that's your mobile and fixed wireless service. And then there is satellite service. So there's been a lot of, as you know, a lot of activity in the satellite realm with respect to the low Earth orbit satellites, Starlink and everything. So a lot of changes there and how that will impact what providers offer services in Vermont is developing daily. And I also just highlight that in terms of networks, most networks are mixed. They are both wired and wireless. So you might have a fiber cable that runs to a cell tower that then provides wireless service, or you have a fiber cable that runs to your house and then you have a Wi-Fi system. So there's usually some element of wireless and wired in any network, generally speaking. So in terms of definitions of broadband, the FCC has a definition, and this is a definition that it uses. Basically, it says, what you need for current applications to use the internet, what they recommend. And so the current definition was set in 2015, 25.3, a lot of talk about how that might be outdated, that there are greater requirements necessary, particularly on the upload end of things, so that you can participate in video conferencing, for example. And then I also just wanted to note that in Vermont, you have a statutory goal of achieving 100/100 service to all 911 locations by the end of 2024. So kind of keep that in mind. You certainly did, as you were crafting your legislation for the last couple of years, how do you achieve that goal? I'm not going to go into the details on this next slide. I'm sure that doesn't look exciting to you, but just to note that the different definitions, the different classifications, whether it's an information service or a telecom service, how broadband is classified, has a tremendous impact on what the state or the FCC is allowed to do.
I wish you would go over the information service in terms of exactly what that means, because I think having a more precise understanding of that might be helpful in guiding us.
Sure. So we can actually read through, I've included here basically the definitions so that you could look at them. And I'm happy to read through them now, though I'm going to look on this screen over here. It's a little easier for me to see. So an information service, this is under Title I. So the Communications Act is divided into different titles, and generally speaking, different titles pertain to different types of service. Although Title I is kind of a general section, which has the establishment of the FCC, its rulemaking authority. And what's always, it kind of trips people up. It's where Congress defined what an information service is, but there isn't a separate chapter or title that governs information services, right? So that's a little bit confusing, I think. So I just wanted to mention, Title I, information service, you're not talking about a category of service, you're talking about general authorities and powers to the FCC. Backing into it, by default, you're not really regulating in a significant way information services. There is no title specific to information services. So the definition that the FCC has developed, that is in the Communications Act, means the offering of a capability for generating, acquiring, storing, transforming, processing, retrieving, utilizing, or making available information via telecommunications, and includes electronic publishing, but does not include any use of any such capability for the management, control, or operation of the telecom system. So I think what's significant here is, and we'll look in just a moment at the definition of telecommunication service. If you think of telecom service as more of a transmission, so a telephone line, it's not the information that's being communicated, it's not your voice, it's not, I mean, just looking at it, using that as an analogy, it's the line itself that allows for the transmission, right? Information service is the processing, computer processing of information that is transmitted over a telecom service. So you can see already how that might be confusing, because when you think of a broadband connection, you're thinking of, at least most people are thinking of a means for transmitting.
Exactly.
Right? So that's been very confusing because some people view it purely as transmission, and it is a telecommunications service, while other people look more at like, well, there's computer processing involved, there's just, the digitization, the IP platforms, and they make more of that argument. And
Well, I'm thinking particularly about voice over internet protocol.
Yep.
And it would appear to be squarely on the issue of telecommunications service as it's included in this definition.
you're 100% right. And on that point, to kind of like just underscore the uncertainty, I don't believe this, unless something just happened the last few months. The FCC has never classified VoIP as either an information or a telecommunication service, but has been treating it as a telecommunication service. And what I mean by that is it allows the state, for example, to apply the universal service charge to VoIP calling, right? We know the Vermont Universal Service Fund, the charge only applies to telecommunication service, your traditional phone bill. That has been expanded to include VoIP calling. Having said that, VoIP is still not classified at the federal level, right? So that you're absolutely right. You keep seeing this convergence of technologies and different uses. And, thank you for understanding that. That was a great illustration of a service.
Yeah. Okay.
So this is just kind of more, this next slide is more.
What is this open internet order on your slide mean? USTA versus FCC.
Oh, okay. So this was the open internet order. This was the challenge to the previous administration. So before the classification under the Trump administration, FCC of broadband as a information service. Prior to that, the FCC had classified broadband as a telecommunication service.
Mm-hmm.
And that is when you saw the net neutrality rules, for example. They said, no, along the lines of this is transmission, this is a telecommunication service, and with that authority that we have to regulate telecommunication service, we are going to adopt net neutrality rules that apply. So that, of course, was challenged. And so that's a reference. The open internet order was the order that did the reclassification to a telecommunication service that was challenged, went through the court system, was upheld. FCC's, so the FCC, I think it's pretty clear that the FCC, although I won't even say that definitively, but at least for the time being, FCC does have the authority to reclassify as it seems appropriate. So that's, I wanted to just reference these different orders that view broadband very differently. And those classifications have both been, so far, have been upheld by the courts. And we're going to defer to the FCC the federal agency with the expertise to determine. I say that's, it's pretty definite that this has authority, but I wouldn't say that with any finiteness, because as the technology changes, I mean, the courts may say, no, we're given how the technology is used, it's not an information, or vice versa. So I just wanted to say that nothing is really set in stone, and that's part of the problem. Precedential value of prior decisions, is a little bit less because the market changes, the technology changes. So you can't just look back and say the courts tell, but this is, that's part of the.
You put your hand up first.
This ping ponging back and forth is, frustrating and I guess I'm wondering, is there a trend when this country started putting telephones and telephone service out there, was the oversight shifting as the technology grew and it became more widespread? Or does this shifting landscape sort of a more modern dynamic that's reflected in our strange politics of this era?
I think it did shift traditionally, the landscape changed, but it was just at such a slower pace. Right, so in 1934, there was a recognition that there are monopolies, much like we think of as the electric utilities. That was the telephone industry in 1934.
Sure.
They had service areas, they were regulated monopolies. And so that was 1934. The deregulation, that started to occur, it wasn't until 1996 that Congress finally said, okay, we need to just get as many providers in as possible because there's services and there's ample competition, and that's going to be better ultimately for the consumer. That was a long period of time. When broadband, there's similar themes and dynamics. It's just evolving so quickly.
Thank you.
Representative Chase?
Trains in the body. With phones as an analogy, was there at any point a similar distinction between the transport and the service? Like there is with information, like the phone lines versus the calls going over them or anything? Or was it always kind of one thing?
Yeah, that's a great question. We don't know if there was. The distinction came up mostly with, go back and see. It was really mostly the distinction of the kind of the information component was more related always to kind of the computer processing. And, the difference between in the 1980s, it was basic and enhanced. So you had your basic telephone connection, which was regulated as a transmission line. And then you had services that were offered over, but it's more like computer processing services where there was, voicemail or access to information databases and things like that. But I don't think, I may be wrong, but I'm not, nothing's coming to mind just in the telephone realm. Although, I guess maybe now that I'm thinking a little bit more about it, maybe the closest analogy might be like customer premise of equipment. Like there's a distinction between like, I can buy my own equipment attached to the phone line, and that's not part of the traditional phone line. So there are those distinctions.
I was thinking more of like an analogy, like back in the 60s or 70s or something, when there wasn't really any technology other than just phones, right? Where there's this simple phone line, and then there would be services that people could access over it, like whatever the equivalent of 411 was back in the day, or where you could call up and, what time is it? Or, other services that could be accessed over the phone line, but weren't specifically tied to it. And if that has any correlation to how the IT side, the internet side, is or could be or should be regulated.
Right. It's a good question. I don't know. I have to do a little more research on the history there, from a regulatory perspective. Yeah, so I'm happy to do.
Okay.
Sure. Yeah. Thanks.
Sure.
I don't want to rush you, Maria, but I am sensitive to the clock and the other things that we have scheduled. And so to the extent that we can.
No problem. I think, what I'm going to do is, I think you understand kind of what the issues are.
Now, this presentation, I believe you gave this to House Energy and
I
Technology.
gave it to the House, and I believe I gave it to Senate Finance.
I don't remember. Do you, Senator Pearson, remember this in Senate Finance?
I know,
I mean-
thrilling. How could you forget?
There are so many
I know.
presentations.
It's worthwhile nonetheless.
But it's so confusing that it's valuable to me to have it again.
I have a hard time remembering things that I actually done myself. So
No, but please go ahead.
I don't know if I get it. So in terms of, I think you were asking a little more specifically, let's try to focus in on what areas can the state regulate in terms of broadband? And where has Congress actually something specific? You can take efforts to improve broadband data. You can enact initiatives to improve broadband, as you have done. Which is different than requiring a company to provide broadband, but whether it's through grants or subsidies. On a competitively neutral basis, states can protect public safety and welfare, safeguard the rights of consumers. I'm going to just diverge a little bit because, there's a whole Consumer Protection Act, and there is that authority, a Consumer Protection Authority. We don't think of it as Department of Public Service. We think of it generally as the attorneys, the Attorney General's office. But in terms of fair business practices, so this might come up in terms of advertising or promising speeds that you don't deliver. So there is that regulatory aspect of broadband. I just didn't want you to lose sight of. Then also the states have the authority to manage the public rights of way and require reasonable compensation on a competitively neutral and non-discriminatory basis. This is
Now, that in
something that's come up.
particular, and we talk about in Vermont, is the Agency of Transportation's ability to ensure that certain cables, for example, that travel down highways, that there is some the ability to charge for the use of the right of way and so on. And I understand that is not being done consistently in Vermont, at least so I'm told. Do you have any familiarity with that?
Yeah, I think that's right. I always have to go back and look at my notes. I just do not trust my memory and I don't want to get it wrong. But there is authority to assess fees with federal funds, certainly on transportation, on highways. There's authority in Title 19 to assess fees on broadband facilities in the state, rights, highways, and I don't, maybe that's more specifically what you're talking about. I don't know that that's being collected, or it might be collected, but I know at one time it may have been collected, but it's a very modest amount.
Yeah, well, one question that I would have for you for the future is to help us understand what the statutory requirement is, and then two, whether or not we're complying with it.
Okay.
Whether or not we're doing what we said we were going to do and the statute allows for.
Yes. Happy to do that.
Good, thank you.
And then ensuring universal service. We kind of spoke about that already. We've talked about this already, the complexity here of a service that has both interstate and interstate components. And we also talked about kind of the federalism, the dual sovereignty, where states can act. And, summarizing very quickly, you know, states can't do things that negate what the FCC is trying to do or conflict with the FCC's policies. You can imagine that's a gray area, but, you know, these are things that are looked at. And then, yeah.
I'm sorry, but when I hear you say that, and then I think about the yo-yoing of the FCC policy, does that, did we do something last year that's totally permissible and then the FCC changes? Or is it a little like our PUC here where when it's enacted, you sort of look at the FCC policy at that moment? Do you follow my question?
That may depend. No surprise there.
Yeah.
Because, well, sometimes whether it's FCC or whether it's Congress, like they might grandfather in.
Yeah.
That does happen. They might
Yeah.
say, well, look, if the state has already enacted law and they're enforcing it, keep it. But going forward, you need to comply, right? So that's certainly happened before. So it really depends
Okay.
what's next.
Yeah. Thanks.
But beyond the authority that's kind of in the Communications Act and how it's laid out, state jurisdiction, there are a couple of things just to keep in mind. And this is kind of getting to the consumer protection issue or traditional police powers of the state. You have that authority to protect your constituency, your citizens of the state. But as you can imagine, at what point might that interfere with federal regulations and federal policies, right? Because forget about the Communications Act for a moment. Congress has the ability, as a sole authority, to actually regulate interstate commerce, right? But states have the authority to enact policies that protect the citizens of the state and their traditional police powers. And that will regulate interstate business. Lots of companies do business in the state and they comply with state regulations generally. The big issue, I think, in broadband is where is that line, right? Where is that line? Because the state may decide for consumer protection or for public safety, there are definite needs where the state needs to take some action. And it will invariably end up regulating an interstate service. But when will the courts come in and say you've gone too far? You're now burdening interstate commerce. And that's a realm that should be left to the FCC or the federal government. And that's a huge area. And as you can imagine, it's not just in broadband. Probably has come up more recently in the area of taxation and collecting online taxes and so on. So, but this is beyond the Communications Act, but a similar dynamic and a similar tension between state authority and federal authority.
With physical products, is the end-to-end service delivery generally considered interstate commerce or only at the border where it's doing the crossing? I'm picturing like mail order something or another. If somebody produces something in one area, presumably it would fall under the regulations of that state for production, but then transportation to another location, firearms, for example, one state might prevent mailing or shipping or transferring products, and that would be interstate commerce. But would the federal preemption just handle the handoff from one state to the other, or the end-to-end?
Not necessarily. It could be much broader. I think so. I'm not by no means an expert on the Commerce Clause, but I know that it's come up in a lot of cases, and basically interstate commerce can be almost anything in the area of commerce. Almost everything is considered interstate commerce or is touched by enough interstateness that Congress can exert authority. So it really becomes, an analysis. If there isn't specific federal legislation saying you can't do this, then it becomes, what is the need that the state is trying to address? Is it narrowly tailored to serving that need? And what's the burden on interstate commerce? And you just do a balancing test. And that's kind of, but most things, Paul, are considered interstate commerce. So It's hard to isolate purely intrastate, but. I know you're running out of time, so I don't, I'm gonna quickly, just highlight the market participant doctrine. Basically, when a state is acting like a market participant in a proprietary capacity, like other consumers buying and selling service, this was the basis for the net neutrality law that you passed, right? So I think you understand that. That's because you procure government contracts and you say who is eligible. Takings clause, just being aware that when you do regulate, you can regulate it and make a service not viable economically, so there may be some compensation. Internet Tax Freedom Act. This is in part why we can't impose the Universal Service Fund surcharge on broadband service. There's a federal law that prohibits that. There are some exceptions. Obviously, you can impose fees for the use of the right of way or on any services used for accessing 911. Again, that could be VoIP, for example. Then there are just a list of general considerations, I think, consistent with everything I've said, keeping things competitively neutral, not discriminating, not burdening industry. And then, I did, this isn't really a cheeky last slide, this is all subject to change. It reflects the reality that it just does change. If there's a reclassification, that's going to change things enormously about what's maybe possible. So that's all I have. I'm sorry that took a lot longer.
Okay.
But that was a large part my fault.
Well, and mine, so please, yeah.
Well, again, though, I thank you very much. I think the background, for most of us, not necessarily all of us who haven't been on these committees before, this is a refresher, and it also reflects just the complexity of what we're dealing with. It's not as simple as it might appear on the surface. And this is having an impact on how we do what we do, and having that background and refreshers is very helpful. So Maria, thank you very much. I believe that Tucker Anderson is with us today, and Maria, I don't know if you want to stay at the microphone as well. And Tucker, I've asked Tucker to be here because there are a number of issues that have been raised between the CUDs, their organizations with which they contract, both for-profit and nonprofit. And so beyond that, in the broadband space, more and more issues have been raised regarding the applicability of the Open Records Act. And I thought it would be useful to have Tucker join us again at a very high level today to perhaps just give us an overview of the Open Records Act as it applies to broadband and our current broadband situation. So Tucker, floor is yours.
Good morning, everyone. Tucker Anderson, Office of Legislative Counsel. As Senator Brock highlighted, I'll give you a high-level overview of the Public Records Act as it applies to the public agencies of the state, and touch upon a few, again, brief high-level issues that will help you burrow down into some specifics related to CUDs when you have your future discussions. So for those of you who have not had the joyous experience of responding to a public records request, or the even more joyous experience of submitting a request to a public agency, I'll give you the very basics. First, the Public Records Act applies to the public agencies of the state, which are the boards, commissions, and what have you of both the state and its political subdivisions. That last part is important because that means it applies to the municipal corporations that are established by the legislature, including communications union districts. The Public Records Act concerns public records, which are defined as any written or recorded material. We can just stop there and not get any deeper into the definition. That is produced or acquired by a public agency in the course of its business. And I emphasized produced or acquired because it is very important to the discussions around some of the records of concern with communications union districts. Under the procedures of the Public Records Act, the agency receives a request and then has a timeline of response that is either 3 business days by default, 7 calendar days if the record is in active use or in storage and cannot be immediately provided, or 10 business days in unusual circumstances. There are a number of unusual circumstances that arise. The statutory unusual circumstances are the need to search for separate facilities, the need to search, collect, and examine a voluminous amount of separate and distinct records. This would be in the event that a request is for a large set of records. A notorious example is any record containing the term fish held by DEC over a 5-year period. Of course, that would not be completed in 3 business days. It would need much longer. The final unusual circumstance is the need to consult with another agency having an interest in the request or with the Attorney General. Setting aside those procedural aspects and not getting into the appeals process, which has its own timelines and procedures, the last item that I wanted to highlight for you is that.
Tucker, may I interrupt with just one question, and that is the timeline issues for anybody who wants to look at exactly what they are. Can you give us the statutory reference for that and also for the appeals timelines?
Absolutely. All of that is within 1 VSA section 318. And for the extended timelines, you're going to look at subsection B. And there's quite a bit of detail in subsection B, not just for the unusual circumstances, but also for how specifically a public agency has to respond to certain requests. When an agency is responding, a public record may be exempt. The list of exemptions, base exemptions, is kept in 1 VSA section 317 subsection C. Those are the general and default exemptions that are listed within the Public Records Act, but that is not the exhaustive list. I have provided for the committee, and it is available on the committee's page, Legislative Council's comprehensive list of the statutory exemptions that are contained within the Vermont statutes annotated. There are 279 as of 2021. This does not include exemptions that exist in federal law, in common law, or as a result of agency rules that allow a particular exemption to be created through the rulemaking process. It also does not account for the judiciary's access to court records rules, which may have other exemptions specific to court records. I will draw your attention to one specific exemption that has been of concern as it relates to your subject area, and that is the confidential business records exemption. The citation that you'll want to take a look at is 1 VSA section 317 C9. This is one of the general exemptions that is embedded within the Public Records Act. First, I will highlight for you that this is an exemption within the Public Records Act that applies to both records and information. It calls out both within the first clause in C9. We can get into more detail perhaps at another time, but the reason this is important is that it will allow either the redaction of information or potentially, depending on the record, a total withholding of the record itself. And that is, again, very important. This exemption allows a public agency to withhold records or information that contains confidential business information that meets 2 threshold requirements. The first is that a commercial concern makes efforts that are reasonable under the circumstances to keep that information secret. So that is a reasonable effort test. Is there a commercial concern that makes either a private company that has provided information to this government agency or the government agency itself want to keep this information secret? Is there a commercial concern and a reasonable effort present? The second, Does this information give its user, important, or owner an opportunity to gain a business advantage? If both of those threshold requirements are met, the information is subject to the exemption and can either be redacted or withheld. We'll pause to give you an important note about the distinction between the Freedom of Information Act at the federal level and how business information is withheld under FOIA, as it's affectionately called, and the Public Records Act, and indeed the Records Act in nearly every state in the US. Under the Federal Freedom of Information Act, confidential business information is withheld if it belongs to the private member of industry that has provided information to the government. If the government agency is the one who is producing the information, it does not meet the requirements to be withheld under FOIA. Vermont's Public Records Act is different. Because of the definition of what a public record is and because of the way this exemption is structured, government agencies can produce business information that can then be withheld. There's a way of saying that the government agency, if it has its own trade secrets or confidential business information, can withhold that information from disclosure. There are a number of cases that have examined this exemption that I would be happy to go into in the future. I will highlight for you now Long v. City of Burlington is the most recent. And the high-level information to take away from that, and I'll provide a copy for Mike to post, is that information that is shared through a public-private partnership may be subject to the C9 exemption, provided that it meets those threshold requirements that we discussed, and that a valid non-disclosure agreement is not necessary for this information to be withheld, but a non-disclosure agreement may be evidence of a reasonable effort that has been taken to keep certain business information confidential. To take a step back and wrap this all up, hopefully as neat as my bow tie for all of you, you are dealing with a public agency that may be producing and acquiring information that due to commercial concerns is withheld from public disclosure. And that may be because these public agencies are acting as market competitors. These are the considerations that you have moving forward. The thing that I'll highlight is that this is a general exemption that is available to any governmental agency that acquires or produces this information. It is not specific to CUDs, but the CUDs are the agencies that have come to your attention and that you may need to discuss in the future.
Questions from members of the committee? Do you, based on what you know, Tucker, at this point, particularly regarding some of the disputes between CUDs and their private partners on the one hand, and advocates and members of the public who are seeking information on the other, is do you see this as an issue that will come before the courts, or do you think it's just very clear cut in terms of the ability of the CUDs to deny access to essentially any information regarding contacts with transactions, contractual details, and so on with their partners?
I'll give you the frustrating answer that it's a bit of both. I think the Supreme Court of Vermont has made it very clear that public agencies can withhold information that they acquire that meet these thresholds under the exemption. There is not yet a decision on whether a public agency can withhold its own confidential business information. At this point, my nascent opinion is that yes, C9 does allow a public agency to withhold information that it produces that meets the exemption. Beyond that, I haven't looked into any particular instances with the CUDs and don't want to comment on it.
Okay, good. Again, thank you very much. For members of the committee, do any members have any questions of Tucker or of Maria, who's still here at this point? Well, again, thank you both for coming in. I think it's very helpful to at least have this overview. I wish we had invited members of the Supreme Court instead of you so that they could have given us definitive answers on all these questions, but unfortunately that wasn't possible today. But again, thank you very, very much. The next item that we have on our agenda today is we're glad to have Christine Hallquist with us today, who is the Executive Director of the Vermont Community Broadband Board. And Christine was good enough to come today to give us at least a brief overview of the opening of the broadband board and what she sees from it. And I realize that in terms of giving oversight to something that is so new, there's very little that we could or should do, but we thought it would be very helpful just to see the landscape from Christine's perspective at this point. So Christine, the floor is yours.
Okay, thank you. Thanks so much for giving me the opportunity to talk about the progress we've made. You know, we've officially, the board's been together for less than a month now, but I'm pretty proud of the work that it's done. And I will, I put a presentation together to give you an idea of what we're doing. Bear with me for a minute.
The presentation too, would anyone like to print out?
Yep. Okay, can you see that?
Yes, we can.
Okay, I'll start from the beginning here. Anyway, I'm very excited to be doing this work because it's so important to the future of the economy of Vermont. So I'm so proud of the work the legislature's done in getting us this far. And I think we've got a great, a really good solution. And I think we're going to have the money to do what we need to do here. So the board has been, I expected the board to be very effective, and certainly it has been effective. If you look at hang on, let me go back here. We've got Laura Sibilia, who you know well, Dan Nelson, who's been the Chief Information Officer at Velco, Holly Groshner is telecommunications lawyer for many years, Brian Otley, VP of Operations and Engineering from GMP, and Patty Richards from WEC. I currently have a staff of 2. We've had 4 meetings. The initial meeting was really just to get started, but office is in place. I'm sitting here in the office. I'd be there around the corner, but I woke up feeling a little out of sorts this morning. So just to be safe, I'm doing this virtually. And we have a website, and on that website, we're going to publish all the minutes and the information. What we've done so far, we've met with the CUD boards, and they're all in various stages of development. The real big number one concern from I think all of us is that we don't want to miss next year's construction season. And I'll be presenting a timeline in a few slides, so I'm coming back to this. We met with most of Vermont's telecom providers, and our goal is to really enhance the partnerships and maximize the optimization of the infrastructure. When I talk about, there are cases where, for example, for a company like Waitsfield Telecom or Champlain Waitsfield Telecom we could give them some money. They could extend their network and get to some customers at easily 1/5 the price it would cost to get there from a CUD. So certainly, I like to talk about the fact that I think it's going to cost about $500 million to get everybody connected in Vermont to fiber optic. We've probably got about $250 million so far lined up. But that doesn't mean that's going to get us there. We have to maximize the utilization of infrastructure. And we're working close with the CUDs to build a good collaborative relationship between the existing telecom providers. And of course, we want to ensure that the existing telecom providers continue to have success. The board has established a number of policy recommendations. That's moving fast. We're in the process of hiring staff. Right now, I have the authority to hire administrative assistant, general counsel, grant administrator, and get some GIS support. And our position was that was what was critical to get us moving. We've developed a set of proposed network design standards and shared them with the CUDs as well as telecom providers. And I'll talk a little bit about more of that in a minute. We've distributed H315 funds to make sure they've got the staff and it can keep moving, and our ability to finalize their partnership agreements. We've also joined a coalition of 5 states through the Pew Charitable Grant. We're going to share best practice between Iowa, Oregon, South Carolina, and Louisiana. We're starting to look at key performance indicators. You know, if we want to get to those indicators that show us how we're doing, here's an idea of some things we're looking at. You know, it's certainly number of unserved addresses, total addresses passed, you know, cost per mile, cost per megabit per second obtained, download and upload, take rate, low income access. We're going to spend some time in the next meeting talking about affordability and low income access. And we're going to have some early indicators of success, and we'll be reporting these out on a weekly basis. And we plan on starting to do that in late October. And we'll from the end connection, we're going to look for software to confirm the speed and latency over time, because we want performance over time as well as initial performance when we get a connection. So our next step is real important, is to finalize the network design standards, and our first workshop is going to be held on September 15th. And I actually take the time. I want to explain these two terms that we're using, because they're industry-wide terms and they're not necessarily well understood, and they have a lot of interpretation. So for our interpretation, you know, we've looked at the CUDs. We want to get the CUD started as quickly as possible on detailed design, because the detailed design is what really determines the construction schedule and materials required and gets into the details. The CUDs have already done high-level designs, and high-level design is essentially a route design, is to figure out where you're going to go. And you know, when you come out of a high-level design, you can kind of get a 70% confidence level of what you're doing. But we want to move as quickly into detailed design, and that's what we're focused on right now. And that's why we need to come up with a set of design specifications, because you know, in the Act 71, it does give the VCBB the option to do a statewide design. Problem with doing a statewide design, I would say most likely we would miss next year's construction season. We can obtain the same results by doing a detailed design spec, and having that detailed design spec, for example, there are going to be requirements in that spec. For example, the requirements will be redundancy and resiliency requirements, and where the interconnect points are going to be with the statewide ring that we'll be developing, and we'll be developing the redundancy with the other geographic redundancy with other states as well. But you know, there are going to be requirements in that, and then there are things we're just not going to get into. For example, do we care at the state level whether we're doing distributed splitters or pole-mounted splitters? Not really. If we look at high-level designs, kind of a route design, detailed design gets into the
Excuse me,
specifics.
Christine, Senator Pearson had a question, I believe.
Sure,
Yeah,
sure, go ahead.
Just on that point, sort of a statewide plan versus the specs. That was one of the, I was, and I think Senator Brock and I were among the people that pushed to have that as an option for the board. And I'm curious, as I thought about it at the time, and I'm jogging my memory here, but it was in part a hope to be as efficient as possible. So take advantage of dark fiber, for instance, or make sure that we're not being duplicative as we build, so that we're cost effective and efficient. Now, you've just said you're not doing it because it will slow us down. So I'm wondering if you could just say a little bit more about that, and I'd be curious to understand the cost protection and the efficiency protection you think that is embedded in your decision.
Sure. Yeah, we deliberated this well because the real issue is time here. If we go out and do a statewide design, first of all, let me start by saying the CUDs have already done their RFPs, and they've gone out and selected partners. And there's partners, and probably the same partners that state would pick. There's top-notch design partners they picked. In fact, I was on the team that selected the partner for the Washington Electric Co-op design, we've got the best in class doing design. So as far as the quality of the partners, they've already selected those. Now, if we have to do that and start over, we have to follow the administrative rule 3.5, which is a good rule, but it sets the requirements out for what an RFP would be. So the RFP, the fastest we could possibly do it, is to be able to select a final vendor would be 3 months. And then if you're doing a statewide design, it's going to take a minimum 6 months to do that. So you got 3 and 6 is 9 months, right? The CUDs have already most have finalized with their partners, and some are under contract today. So we cut 3 months out of that because they don't have to do the RFP. And then doing a parallel effort, they could do it in 4 months. So you've taken 5 months out of the schedule. And I'll show you the timeline later on. The timeline right now has us optimistically starting construction in May. So if you add 5 months, basically you lose next year's construction season. So dealing with that, our board debated that thoroughly. And we do, not only can we say we will be able to meet the same by setting a set of clear design specs, doing a series of design workshops to make sure the telecom companies and the CUDs understand the design requirements. And then we will review those designs at the state level.
Great, thank you.
Yep.
So is it fair to say that you will not have the classic railroad problem of having each railroad build something that has different gauges?
Yes, I'm not sure I'm assuming you're talking about the fiber itself. Yes, we're going to have standards around fiber, and we're going to have standards for the amount of tubes that are left dark and available for public safety, future growth, and future competitive.
Will all this connect together well and connect together consistently?
That is going to be, yes, absolutely. That's very important. That'll be part of the requirement, is we're going to define the interconnection points.
Okay, thank you.
Yeah.
Please.
So next steps.
Please go ahead. Yes. Mm-hmm.
Okay, shall I continue?
Yes, please.
Okay, so the next steps is to get those detailed designs started ASAP. And when I say ASAP, unfortunately, ASAP isn't really that fast, because what we need to do first is come to an agreement on that design specification and put that in place, because we don't want to necessarily start the design without having the design specification. That wouldn't be very smart. So, that this whole putting together design specification is critical, but it is causing the CUD some heartburn. But it's a necessary step. that we have put in place. The CUDs need to finalize their partnership agreements, finalize any of the CUD town telecom provider relationships as well. And we're playing an active role in that at the CUD level. Make sure the CUDs are staffed so that they have, a number of CUDs right now are in the process of hiring their executive directors, and getting a good solid executive director in place is critical so we can carry this out. To finalize our budget, we plan on doing that within the next meeting or two. And by the way, we're meeting weekly. And now the update and verify the baseline data. That's critical. In the Act 71, the DPS continues to report the broadband status of the 911 addresses. And it's kind of critical that we get that data as soon as possible so we can start reporting on our performance metrics. The good news is the DPS, they normally report that data on an annual basis, and we've kind of gone back and forth, and they've agreed that they can get that done by October, which meets our needs. So I'm very happy that the DPS has been supportive on that. And that ties to establishing the key performance indicators. We're going to do some additional CUD workshops, grant management, organizational development. The first priority is to do the design workshops. And of course, I should add to that, I made a personal commitment to the Hoyt Farm that we would do this, is we would also have workshops and standards on contract management, as well as the good management practices in field safety and field housekeeping. And one of the critical areas, which I'll identify as kind of what our concerns are, is we really, if we look at, there's two areas that we're going to face: material lead times and human labor shortages, because the whole country is chasing this money down to build fiber infrastructure, and of course, we only have limited human resource needs. So I've had some initial meetings with the Department of Labor. Really, I look at it as one of the key constraints that we need to focus on at the VCBB is labor. And I've looked at the Kentucky model, which is nice, Kentucky Wired. They've put together programs to do training at their technical schools and their colleges, and they're getting 57% of their human resource needs from in-state. So it does create a great opportunity for growth for the residents of the state in terms of career, but we're going to need to do a lot of work to make that happen.
Senator Pearson?
Just out of curiosity, how long is that? A semester, a year? What kind of, how long is the training that you're seeing in Kentucky?
I don't know the answer to that. It wasn't a year. It was either 8 or 12. I think it was 8 weeks for fiber splice. It's different. It depends on what skill level you're looking for. We're going to have different skill levels, and those are going to take different amounts of time. But initially, we need fiber splicers.
Thanks.
Are these people who climb the poles?
Well, this work will be done out of, they're going to have to climb poles, aren't they?
Well,
yep. Yes, they're going to have to climb poles, or at least put a ladder up on the poles. They're not working in the electrical space. They're working outside the electrical space. Right. But as you accurately point out, in our rural areas, a lot of our poles are off-road. So there will be some pole climbing and some ladder use.
Thank you.
Which really gets, it really gets into the importance of good safety protocols. And good safety protocols, it doesn't just come from the contract and the insurance. Good safety protocols is the training and the field supervision. Because you can do all the training in the world, but if you're not carrying it out, it's not, and you're not ensuring it's being carried out, then you don't have a good safety program. So it's the reason I say that is because the minute you talk about climbing poles, now we get into the issue of the quality of the pole itself. And I've seen a number of injuries over my time because of rotted poles.
And of course, obviously not dropping wire in the hay.
Yeah, that's a housekeeping issue, of course. And but I can assure you, wherever there's bad housekeeping, there's going to be bad safety practices. The two go hand in hand.
Interesting.
So in other words, we're not just. Go ahead. Sorry.
I just a question regarding the timeline and some of the issues that you've talked about detailed designs and so on. Are all of the CUDs at the same stage in this process, or are they able to be within this process in order to get some construction done in the next construction season?
No, not all of the CUDs are in the same state. And we looked, and we've talked about this at the board meeting yesterday. We view it as our job to get those lagging CUDs up to speed as quickly as possible. So certainly, I won't mention any names because I don't want to offend any of the CUDs. But certainly, if you look at EC Fiber, clearly they're a mature the organization that we don't need to focus as much on. NEK Fiber, CV Fiber, they're going to be focused on design issues. They've got their organizations pretty much in place and their plans in place. And then you get to some of the other CUDs that we need to work with them to get the staff they need right away. And we are doing that. So no, they aren't all at the same place, and we're going to have to deal with each one of those differently.
One of the things we've talked about is the policy goal in statute of 100 universally by 2024. Should the legislature revisit that timeline?
Well, it's not going to happen by 2024. You look at the physics of construction. If you look at the ARPA grants, say we need to get construction pretty much finished by the end of 2025. It's going to take to get that last Vermonter connected to fiber. If we didn't have material or labor shortages, we could get it done in 5 years. But I've been consistently saying it's going to be 5 to 7 years to get that last Vermonter connected to fiber.
Well, I guess that's one of the things that perhaps to take back to the board, I think it would be helpful to us in the General Assembly if we had a recommendation from the board as to what is a realistic statutory goal for getting all this done.
Yeah, I think we owe you that. Certainly by legislative session, we will have a recommendation. It'll be more than just my opinion.
And as we talk about this expansion, are there territories right now that are not covered by CUDs?
Yes, and we've been meeting with those and working solutions with those. Good example is the.
You'll be working on a solution to perhaps come back to be able at some future point to tell us how we deal with those areas.
Yeah, we're actually dealing with those areas, so I think we're going to have that covered. But yeah, we could. We're certainly. For example, this week we met with Burlington Telecom and the Chittenden County Regional Planning Commission to look at individual pockets. For example, there's some pockets in Colchester that clearly it would not be effective for the CUDs to serve. So, we'll encourage the local telecom providers to get out to those pockets. But the legislation allows us to do that today, which is good.
Mm-hmm. In terms of fiber, some discussion I recall in committee from time to time regarding active versus passive fiber in terms of the statewide design. Do you have any thoughts on that, or is that an issue that's under discussion?
Yeah, I don't. Some people are trying to. When you're doing a rural network, you've got to do passive optical networks. And by the way, passive optical networks, I can cite the IEEE papers, the designs, the passive optical networks do a fine job of backhauling mobile wireless data and other data. The reason passive optical networks are important for rural networks is because of reliability. An active, a passive optical network does not require the power supplies that an active ether network requires. Those power supplies, anytime you've got a power supply, you've got cost. You've got to put a 10 by 12 building up for the cost of about $100,000. You've got to make sure you've got backup power. My experience as VC as the CEO, when we had power outages, you could have batteries and you could have generators in place, but a third of the generators wouldn't start because they aren't maintained. The batteries go bad over time. So, it really is important to run passive optical networks from a rural perspective. Certainly, as you get closer to urban areas, you can do active Ethernet. We're not excluding active Ethernet. It's just the passive optical network will accomplish all the goals we need.
Thank you. Do you have anything more that you'd like to add to the discussion today?
Yeah, I'm just going to summarize most important things to focus on: lead times, human resource availability, maximizing existing infrastructure, and accelerating the growth of the CUDs.
Okay, Senator Pearson.
I want to come back to workforce because it seems in some ways, maybe materials as well, the one we have, in a sense, the least direct control over. And the training sounds like you've starting down a path of developing a strategy around training. But I'm curious, would we expect to see like ads for people that want high-paying jobs starting in June? I mean, what's the strategy to get people to take the training to become expert in this? It does seem to me a pretty promising and likely ongoing career opportunity, in the sense that even here in Vermont, but then more broadly, highly portable. But what's the strategy? It sounds like we've figured out how to train them, or partnering with some of our institutions to train folks. But what is the thinking, and forgive me, I know you've only met for a month, but how do we actually drive people to make those choices?
Well, one of the things we talked about in my discussion with the Department of Labor is, there are various programs, and my personal belief is we've got to use every program possible, because you look at the trouble we're having getting labor today, coming out of this COVID crisis. It's not a matter of doing one thing; it's a matter of doing everything. So, for example, and again, we'll be coming back to the legislature with recommendations, but earn to learn programs. Because if you take, of course, we want to give Vermonters the opportunity to grow in their career, but people struggling at the lowest part of the income ladder, they can't afford to leave even their low-paying job in order to get the training. So, the state, such as other states have done this, they put together these earn to learn programs where we pay them while they're getting training. But you do this but you're also partnering with the telecom companies and having an assurance that they'll hire these people at the out part of the program. So you involve the private industry in saying, look, help us, you're going to be part of the selection process of the candidates that go into these programs, so that, because you don't want to take taxpayer money and waste it. You want to make sure that when you've got somebody in an earn to learn program, that they have a job when they come out. So that's one example. But even working with the state prisons to give people an avenue to learn over. There's another labor resource which we can turn into, to make much more productive. But we do need to tap, I think, every possible labor source there is. Does that answer your question?
It does. And then what about the 33% that we envision not being Vermont, or are we exploring contracts for those firms at this point, or is the thought that we'll have that, where does that come from? You said the Kentucky model.
Well,
is
as you know, I've
57%.
already started discussion with some Canadian companies because,
Okay.
more than likely, I'm hoping the other states haven't done the same thing, but since Canada doesn't have these programs in place, there are resources available there. So I've talked to at least one company in Canada.
Okay, and is there any hope we're just 6 months ahead of the other states? I mean, we have been, I think people tell us we should be pleased with the CUD model, and maybe we've been thinking about this or slightly more organized, or are we kind of on par with a lot of our neighbors in terms of our readiness?
I don't know the answer to that. I really don't. I'm hopeful we are, but I am part of that Vermont exceptionalism group. But
thank you.
Any other questions from members of the committee?
yeah, let me just close one thing, just to answer Chris's question. I will ask that question as part of the next meeting we have with our state peers.
Great.
Thank you.
Thank you. Anything else from members of the committee?
Yeah.
Yes, proceed.
Oh, no, I don't have any additional questions. I just want to make sure I answer the committee's questions.
Okay. Well, great. Well, thank you very, very much for joining us today. I'm sure we'll see you back again at some point, and hopefully with great news. So thank you again for coming today.
You're welcome. Thank you for your time.
Okay. We have a few minutes left before our adjourning today to talk a little bit about the future. There are a number of issues that we will obviously be addressing, including the non-public portion of the testimony from ADS, along with hopefully some of that same information, both from the judiciary and from the legislative branch, which we will try to tee up for our next meeting. There are a few things that both Representative Feltus and Senator Chittenden supplied in terms of subjects of future discussion, and we're going to try to incorporate those into our agenda for meetings in the not too far distant future. I would ask other members of the committee that if there are subject areas or issues to bring forward to do so that we make this a useful exercise for all of us. Major issues that we're going to talk about and have sessions specifically about are the cybersecurity area, the ransomware area, some of these major vulnerabilities. And in the executive session that we have to talk about specific vulnerabilities and critical IT areas of focus and interest going forward. I see Representative Sibilia has a comment.
Thanks, Senator Brock. More of a question. Will we be getting updates on progress for the major IT programs that we provided funding for this year, like on a regular basis? Is that something that we're going to be incorporating?
Yes, it is.
Okay.
It is.
Okay.
Absolutely. We'd like to know where the money went.
Well, and how those projects are being, how those projects are.
And whether or not we're
rolling out.
accomplishing what we intended to do. And it's just that focus and that I think is an essential oversight role of this committee.
Yeah, I mean, it's a lot of dollars. It's nowhere near enough. It's a lot of projects, just the, tip of the iceberg, but it's a key role for this committee. And, I'd like to see us trying to, if we can, squeeze one of those into every agenda if possible. One of these, just getting an update on one of these major IT projects and where they're at.
Okay. And I've made a note just to make sure it doesn't get forgotten by me. Thank you. Anyone else have anything to add at this point? The one thing that I would add is the notes from Representative Feltus and Senator Chittenden were particularly helpful in focusing on some areas that are important. And I would ask other members of the committee, it would be very helpful if you do have those thoughts to put them in writing and get it to us so that they can help form these agendas going forward. We will put out a doodle poll regarding the next meeting, which should be sometime later in the month. And we'll get that out timely so that we can begin the schedule. And we'll also focus on getting an agenda to you in a more timely fashion.
And just to clarify, we're going to differentiate the doodle poll between in-person and remote availability.
Yes, and I'm hopeful that we're going to get some more guidance from the Joint Rules Committee regarding what we do in terms of in-person versus non-in-person. The guidance has been a bit inconsistent. The initial guidance before the July 15 date was that all committee meetings would be in person and that there would be only exceptions made for people, for such as someone is ill or what have you. But that has not been the case, and it's been very inconsistent. And I think we just need some clarity as to what we're doing. That is part though also is just the uniqueness of having to do the executive session situation where we are today. And I want to try to get some better clarity from Joint Rules on that as well.
I'm not clear if Representative Sebelia's got a fresh hand up or if that's an old one.
It's a fresh hand.
Yes.
Just a question, Senator, and I'm not sure what the procedure is in the State House. I see that we have folks that are unmasked, and I realize that that's not a mandate in the State House. Senator, I would hope that for our meetings, we could ensure if this was not in fact done, and of course I was not there this morning, that we are offering asking every member of the audience to mask and making sure that we have masks that are available for them if they are there and choosing to be respectful of everyone's health. So I just wanted to make sure for our next meetings that that's something that we're doing.
Okay. Thank you. Senator Pearson?
I'm curious, last meeting, we had by charge of the budget, I think, a decision
We did.
to release funds. And do we have other milestones like that?
Those are the only milestones that I'm aware of that involve the release of funds were those two instances which we dealt with at the time. I'm not aware of anything else. I will double check. But I'm told by legislative council that those are by JFO that those are the only two that are specific in that regard.
Thanks.
Okay, do we have anything further to do before we adjourn today? If not, then a motion to adjourn.
So moved.
And second? In favor?
Aye.
We are all adjourned and we're 2 minutes early.